Good. Okay. So thank you very much for inviting me to speak at this distinguished conference. So my subject, as you can see from the screen, is the constitutional turn balancing copyright and freedom of expression in English law. And I can just figure out how to move forward. There we go. A brief overview of what I'm going to be talking about. Firstly, the scholarly debate over constitutionalizing intellectual property law. Secondly, to make the point that tensions between IP law, particularly copyright, and fundamental freedoms, particularly freedom of expression, are nothing new, by reference to two old English cases. Then I'm going to briefly touch on section 171, subsection 3 of the 1988 copyright, before moving to the impact of the Human Rights Act 1998, and lastly, the impact of the jurisprudence of the Court of Justice of the European Union. So the starting point really is a famous article by the scholar Christoph Geiger, Constitutionalizing Intellectual Property Law, the Influence of Fundamental Rights on Intellectual Property in the European Union, which dates from as long ago as December 2005. And in his article, Geiger proposed that constitutionalizing intellectual property law by grounding it in human rights and fundamental freedoms would help to achieve two related objectives. Firstly, to check overprotection by intellectual property law, and secondly, to give intellectual property law greater legitimacy. Since then, there has been a burgeoning of the literature on this subject, and the issue has increasingly surfaced in the case law of the Court of Justice of the European Union and of the national courts across Europe. Interesting, there's also been a bit of a scholarly backlash because in recent times, some scholars have questioned the benefits of constitutionalization. But nevertheless, the debate is still a lively one. Now, it's important, I think, to remember that tensions between particularly copyright and freedom of expression are really nothing new. And I'm going to illustrate this point by reference to two famous English cases of the late 60s and early 70s. So the first case is Fraser and Evans. And in that case, Maurice Fraser was a PR consultant engaged by the Greek government. He wrote a progress report on his work, a copy of which was leaked to Bruce Page of the Sunday Times Insight team during the editorship of Harold Evans. Page and a colleague interviewed Fraser and revealed that they had obtained a copy of the report. Fraser obtained an ex parte interlocutory injunction restraining publication of any information derived from the report. This was continued after an inter partes hearing, and the Sunday Times appealed. The Sunday Times admitted that it intended to publish an article which would be defamatory of Fraser, but said it would justify the facts reported and rely upon fair comment. It followed that no injunction could be granted to restrain publication of the article on the ground of defamation. Accordingly, Fraser relied upon breach of confidence and on copyright in the report. The claim based on breach of confidence failed on the ground that any obligation of confidentiality was owed to the Greek government and not to Mr. Fraser. As for copyright, the Sunday Times said it would only print short extracts from the report and rely on the exception for fair dealing for the purposes of reporting current events. The Court of Appeal held that it would be wrong to prejudge this issue by preventing publication. Lord Denning, Master of the Rolls, gave the main judgment, in which he concluded with the quotation I've put on the screen. It all comes back to this. There are some things which are of such public concern that the newspapers, the press, and indeed everyone is entitled to make known the truth and make fair comment on it. This is an integral part of the right of free speech and expression. It must not be whittled away. In Husband and Vosper, L. Ron Hubbard was the founder, of course, of the Church of Scientology and the author of numerous books and other documents concerning Scientology, some of which were claimed to be confidential to members of the church. Cyril Vosper had been a member of the church for 14 years. He published a book which was very critical of Scientology. On the day of publication of the book, the church obtained an ex parte interlocutory injunction restraining publication. Subsequently, Hubbard was added as a plaintiff and the injunction was continued after an inter partes hearing. Vosper and his publisher appealed. As in Fraser and Evans, the plaintiffs relied upon copyright and breach of confidence. There was no dispute that Vosper's book included quotations from a number of Hubbard's books and documents. The defendants relied, again, upon the exception for fair dealing for the purposes of criticism or review. The Court of Appeal held that the defence was an arguable one. Similarly, it held that the defendants had an arguable defence to the breach of confidence claim that publication was in the public interest. In those circumstances, it held no injunction should be granted. Again, the main judgment was given by Lord Denning, and his conclusion, again, I've put on the screen. If what Vosper says is true, it's only right that the dangers of this cult should be exposed. We never restrain a defendant in a libel action who says he's going to justify. So in a copyright action, we ought not to restrain a defendant who has a reasonable defence of fair dealing, nor in an action for breach of confidence if the defendant has a reasonable defence of public interest. The reason is because the defendant, if he's right, is entitled to publish it, and the law will not intervene to suppress freedom of speech except when it is abused. Now, although no reference was made in either Fraser and Evans or Hubbard and Vosper to the First Amendment to the US Constitution or to US case law, both cases were emphatic vindications of the principle that a free press should not be subject to prior restraint except in clear cases. And this may perhaps what lies behind the slightly curious provision that we still have in section 171, subsection 3 of the Copyright Designs and Patents Act 1988, which says nothing in this part affects any rule of law preventing or restricting the enforcement of copyright on grounds of public interest or otherwise. And it's worth noting that that's not even in the same chapter of the Act as the chapter setting out exceptions and limitations to copyright. And it puts UK copyright law in a somewhat unusual position in that in addition to the usual internal mechanisms available under most of developed copyright laws, such as the originality requirement, the test for infringement and exceptions or limitations, it enables freedom of expression to be invoked as a defense to copyright infringement, even if no other specific provision is applicable. And to that extent, it might be said that constitutionalization is legislatively mandated by UK copyright law. So we then turn to the next significant development, which is the Human Rights Act 1998. And the significance of this is that although the UK famously lacks a written constitution, the 1988 Act gives effect in domestic law to most of the provisions of the European Convention on Human Rights and Fundamental Freedoms. And it follows that the UK now has a proper basis for a constitutionalizing approach to these issues grounded in European norms. And the effect of that in the short term was very limited. And this can be seen from two cases decided by the Court of Appeal either side of the date the Act came into force. The first is ProSieben and Carlton. In 1996, a woman called Mandy Allwood found herself pregnant with 8 embryos as a result of fertility treatment. She and her partner, Paul Hudson, engaged the services of the then well-known and subsequently disgraced PR consultant, Max Clifford, who sold their story to various media organizations. One agreement made by Clifford was with the German television company ProSieben for the exclusive right to broadcast an interview with Ms. Allwood and Mr. Hudson in Germany. A 9-minute item, including footage from the interview, was broadcast by ProSieben as part of a magazine program called TAF. The UK television company Carlton subsequently broadcast a 25-minute program entitled, quote, Selling Babies, as part of its flagship current affairs strand, The Big Story. The program was a critique of checkbook journalism of the kind it exemplified by the Orwood story, and in particular of the role of intermediaries such as Clifford. It included a 30-second extract from the TAF report. ProSieben sued Carlton for copyright infringement. Carlton relied upon the exceptions for fair dealing for the purposes of criticism of review and of reporting current events. ProSieben were successful at first instance, but the Court of Appeal allowed Carlton's appeal, holding that the use of the extract fell within both exceptions. The sole judgment was given by Lord Justice Robert Walker. Although he did not refer to the Human Rights Act, which had recently been passed, he did note that the provisions in Chapter 3 of the Copyright Act were all directed to achieving a proper balance between the protection of the rights of a creative author and the wider public interest, and that free speech is an important part of that wider public interest. He went on to say that criticism or review and reporting current events were expressions of wide and indefinite scope which should be interpreted liberally. He held that the inclusion of the extract was for both purposes and that it was for fair dealing. As such, the decision was clearly one which respected freedom of expression. The second case is Ashdown and Telegraph. In that case, Paddy Ashdown was an MP and the former leader of the Liberal Democratic Party. In October 1997, he and 3 others from the party had attended with the meeting with the then Prime Minister Tony Blair to discuss potential cooperation between the Lib Dems and the Labour Party. Afterwards, Ashdown dictated a minute of the meeting, which ran to 9 pages when typed. 2 copies of the minute were made. One was added to his diary and kept in his safe. The other was read by a small number of close advisors and then shredded. In November 1999, the Sunday Telegraph obtained a copy of the minute and published 3 articles based on it. The main article included several verbatim quotations and almost verbatim paraphrases, amounting in total to about 20% of the minute. Ashdown sued the Sunday Telegraph for infringement of copyright and breach of confidence and obtained summary judgment on the copyright claim. The Sunday Telegraph appealed, relying upon the exceptions for fair dealing for the purposes of criticism or review and of reporting current events, and also upon Section 171, Subsection 3. The Court of Appeal dismissed the appeal. It held that extracts from the minute were not reproduced for the purposes of criticism or review, and that although it was well arguable that the extracts were reproduced for the purposes of reporting current events, given that that expression was to be interpreted liberally, and given that the exception was clearly intended to protect the role of the media in informing the public about matters of current concern to the public, the extent of reproduction exceeded what could be regarded as fair dealing, and that freedom of expression did not require such extensive reproduction to be permitted pursuant to 171(3). Although the result favoured the copyright owner and has been criticised by some scholars for that reason, 3 points should be noted about the decision. First, the Court of Appeal placed the Convention on Human Rights front and centre in its analysis. And it relied upon decisions from the European Court of Human Rights. It went on to say, in the quotation from the judgment of the court that I put on your screen, rare circumstances can arise where the right of freedom of expression will come into conflict with the protection afforded by the Copyright Act, notwithstanding the express exceptions to be found in the Act. In these circumstances, we consider that the court is bound, so far as it is able, to apply the Act in a manner that accommodates the right of freedom of expression. In such rare cases, the court went on, the right to freedom of expression trumps the right conferred by the Copyright Act. Secondly, the Court of Appeal accepted that it would have been legitimate for the newspaper to report the existence and contents of the minute and to quote 1 or 2 short extracts from it. What the court objected to was the extent of the quotations. Thirdly, an important aspect of the case was there was evidence that publication of the minute destroyed part of the value of the memoirs which Ashdown had been intending to and did publish. And in that respect, the Court of Appeal's decision was exactly the same of the decision of the US Supreme Court rejecting the defense of fair use in a very similar case concerning President Ford's memoirs. What has changed since those two cases is the impact of the jurisprudence of the CJEU. And the point, I think, is best illustrated by what I believe to be the current leading decision, which is actually one of my own, given at first instance, in England and Wales Cricket Board and TICSTAC. And in that case, the claimants were the owners of the copyrights in television broadcasts and films incorporated within such broadcasts of most cricket matches played by the England men's and women's cricket teams in England and Wales. The defendants operated a website and a mobile application. The defendants' employees, contractors, and users uploaded a considerable number of clips of broadcasts of cricket matches, each lasting up to 8 seconds, to the app where they could be viewed by users. Users could also view such clips on the website and on the defendant's Facebook page and Twitter feed. The claimants contended that the defendants had thereby infringed their copyrights. The defendants denied infringement, relying primarily upon the exception for fair dealing for the purposes of reporting current events. A defense of fair dealing for the purposes of criticism or review was not pursued, and no defense of fair dealing for the purposes of quotation was ever advanced. And I've put on your screen the key passage in the judgment, where I said as follows: it's common ground that Article 5.3c of the Information Society Directive and Section 30, Subsection 2 of the 1988 Act must be interpreted and applied in conformity with Article 10 of the Convention on Human Rights and Article 11 of the Charter of Fundamental Rights of the EU. As is also common ground, however, the defendant's right to a freedom of expression is a qualified right and must be balanced against the claimant's intellectual property rights, which are protected by Article 1 of the First Protocol and Article 11 of the Charter. Finally, it's also common ground that Section 32 contains a balancing mechanism within it, since it requires an assessment of fair dealing. Although Article 5.3c does not so obviously contain such a balancing mechanism, the requirement that the extent of the use be justified by the informatory purpose can readily be interpreted as embodying a balancing mechanism. Moreover, it's clear from recital 31, let me move on, and the decisions of the Court of Justice interpreting Article 5.3d and k of the Infosoc Directive in the Painter case and the Deckmin case, that Article 5.3c must in any event be applied, as the Court of Justice put it in the latter case, so as to strike a fair balance between, on the one hand, the interests and rights of persons referred to in Articles 2 and 3 of that directive, and on the other hand, the freedom of expression of a user of a protected work who is relying on the exception. Now, the decision in the case was that the exception didn't apply because the use in question was not for the purpose of reporting current events. But what I would draw attention to is the recognition given to the principle articulated by the Court of Justice that exceptions must be interpreted and applied so as to strike a fair balance between copyright and freedom of expression. And in that way, I would suggest that the English courts have recognized that decisions in cases involving conflicts between copyright and freedom of expression needed to be grounded in the European human rights framework. Thus, some progress has been made towards constitutionalization of copyright law, although some scholars would argue that further there is still some way to go. Thank you for your attention.